Session is intended to serve as a bridge between legal, economic, and industry professionals to discover governance first principles that best serve India's interests. We have an absolutely stellar panel of academicians, jurists, and industry professionals with us today who have graciously accepted to spend a Friday evening discussing this rapidly developing, very dynamic field. For the attendees who have joined us and are watching on YouTube Live, please feel free to tell us your questions, thoughts, and opinions through the comment section on YouTube. The panelists shall respond to them during the second half of today's discussion. I would first like to call upon Professor Tanvi Nandan, Assistant Dean at the Jindal Global Law School, to take 5 minutes and introduce the objectives of this discussion and the significance of creating conceptual bridges between practitioners and students. Professor?
Hi, thank you, Richa. Good evening, everyone. Welcome to this discussion today that I'm very grateful and happy to be a part of. Just to take up a quick 5 minutes to introduce what we are hoping to achieve through this session, I thought that I would also take this opportunity to introduce the organizers of the session, which is JDCIL and SIA Center. The SIA Center is a New Delhi-based tech policy think tank, which works on the intersection of innovation, people, and value. As part of their research objectives and aims, they encourage a multidisciplinary ethos for research and cross-pollination between researchers and practitioners under different thematic areas such as competition and IPR. The other organizers are the Jindal Digest for Competition and Innovation Law, which is a student-edited interdisciplinary legal blog aiming to provide a view of the contemporary developments in antitrust law, intellectual property law, and technology law. And through the forum of JDCIL, they aim to fill in a critical lacuna by providing accessible, quality-driven literature, focusing on rapid legal developments in antitrust law, IPR, and technology law. On behalf of Jindal Global University and Jindal Global Law School, I'm very happy to welcome you all to this talk. I think that we are all very aware of how cutting edge and new laws and legal developments require an interdisciplinary approach. They require engagement between the academic sphere and practitioners. There is a need, as Richa rightly pointed out, to bridge the gaps where it may not be enough to just rely on state capacity, and it may be beneficial for all stakeholders to involve outside experts. I think the United States is an example of a jurisdiction where this is already happening. And in India, with all the legal experts and academic experts, this could be something which is very beneficial. There is a need for greater generation of knowledge and trust, which can only happen through interactions like today's, where we involve experts from all these different fields to share their knowledge, to create a broader base of and a database of understanding, and carrying out these reflexive capacity building exercises where industry stakeholders and government stakeholders can work together and work in a collaborative way, particularly in areas like competition law, which require this kind of interface and interdisciplinary approach more than anything else. So we are, of course, all very excited to hear everything that you all have to share with us. And I am absolutely sure that this will be a very fulfilling and fruitful discussion. So thank you all for being here. And I hope that we have a very productive evening.
Thank you, Professor. May I now ask Mr. Gopal Jain, Senior Advocate of the Supreme Court of India and a member of the Board of Advisors to the SIA Center, to give us his opening remarks. Sir, please.
Good evening. We have to see the history of competition reforms in India dating back to pre-1991, when India was a fairly closed economy and followed a strategy of planned economic development with a lot of controls and licenses characterized as the license Raj, till India embarked upon the road to a market-driven economy. One of the first things which comes from opening up and having a market-driven economy is you need independent regulators. So the opening up of the Indian economy in the 90s, doing away with licensing Raj, lowering trade barriers, removing tariffs, ushering in foreign investment by changing from the more draconian FERA to FEMA, worked wonders to increase competitiveness of domestic industry, but equally it required a regime and a framework to deal with competition-related issues. It is in this context that the Competition Act came to be sometime in the year 2002, and the whole object was how do you ensure freedom of trade by preventing practices which could have an adverse effect on competition. But the large part of the focus, both of the and the Competition Commission, was really on conduct and on enforcement, and it has been fairly heavy-handed and high-handed at times with a huge penalty-driven culture, because that was the beginning period. At that particular time, India did not have a competition policy, and the mindset still was of a closed economy and a license Raj with a large number of government controls being in place, because these were early days. As a result, true competitiveness and economic competitiveness was hard to achieve because there was no mindset change, and this was still in the early part. The Act, I must say, did not really stimulate that competitive landscape, the competitive behavior, strengthening of markets, because the overall environment was not conducive at that particular point in time. Now, importantly, as we attempt towards moving towards a digital market, some of the key questions which come up is, how do we strengthen markets? Has the Competition Act worked so far? Has it strengthened markets or has it replaced markets? Has it created many blind spots? And how is it these blind spots can be addressed as we head towards a digital era in economy and finally into a digital market? It's in this context that first principles approach becomes important to competition. And the main reason we require these first principles is that competition regulation is a complex doctrine and requires specialized understanding of economics and market dynamics, the interface, so as to put it. We've had the CCI, which is a quasi-judicial body, and the nodal competition authority as far as India is concerned. We also have other sectoral regulators like the Telecom Regulatory Authority of India or the Electricity Regulatory Commissions, which to some extent overlap with the CCI as far as competition-related issues are concerned. So there's some turf overlap. But the key thing is that these sectoral regulators don't have a clear understanding of the economics which can make a sector. They are more general physicians who know the sector. In addition, the Indian regulatory system has what is called a regulatory adjudicatory system, where challenges and appeals to regulatory decisions go to the next level. But these, fortunately, have not really had the benefit of experts. So while there is a process of appeal and eventually it goes to the Supreme Court, and Justice Sikri dealt with some of these issues, but having non-specialized forums or bodies without the necessary expertise, people who are not fully competent to handle these complex issues and challenges, resulted in varying set of decisions. One decision by a regulator going one way, the appeal fully reversing it, Supreme Court taking a different view, created a lot of uncertainty. So that's why it's very important to bring in competition policy and to have first principles. Now, competition in the digital market will be very different from those in the traditional markets, because digital markets have their own unique DNA and many facets and factors, and they're very goal-driven towards innovation, towards stimulating investments, and using technology as a competitive weapon. So it's very important that with the arrival of digital markets, which could add to the complexity of competition regulation, it requires a specialized understanding of economics and competition. So I may use the word, requires some handling with care, but also a greater technical understanding. And therefore, if these first principles can help in cutting across the complexity of competition regulation by distilling the technological intricacies and economic theory down to its barest form, by making even the most nuanced concepts accessible to non-specialized courts and sectoral regulators, it will bring in a lot more consistency in outcomes, and having a holistic, forward-looking and consistent futuristic approach will also help us by formulating these principles to navigate the digital ecosystem of digital markets. Here we can take guidance from first principles, which are important for regulating competition, and look to best practices, global best practices, which can again facilitate competition in the digital markets, particularly those from advanced markets where you already have these principles at play, which have worked. So it's really in this context and background, we felt if all of us come together and we can channelize our experiences and expertise in this room in debating about what would be those guiding principles for decision makers in this country as we embark on regulating competition in the digital space. And perhaps this discussion would lead and be a first step in formulating this framework for competition regulation, and perhaps leading to better decision making and outcomes, which is the need of the hour. So I just wanted to set the stage for the discussion by giving this context. And hopefully, as I said, our discussions would lead towards deliberating on the appropriate first principles and policy which is required for digital markets. Thank you.
And thank you for enumerating upon the urgent need for first principles in competition policy and digital markets. Before we begin with the actual discussion, I would like to invite Ms. Meghna Bal, who is a lawyer focusing on technology and policy issues and a consultant for the Cohen Advisory Group. She will take us through a 10-minute expert presentation to set a broad context in which today's discussion would be placed. Ma'am, could we have your presentation, please?
Sure. Thank you, Richa. Hi, I'm Meghna, and I'm working on emerging tech-related issues at Cohen, a boutique policy advisory firm based in New Delhi. I thank our hosts for giving me the opportunity to present today. Broadly, the structure of the presentation is as follows: why we need first principles, and first principles to understand competitive harms in digital markets, just to get the ball rolling. Physicist Leonard Susskind says that where principles collide, progress is made. Of course, he said this in the context of quantum physics. It is our hope to provoke a similar clash in principles on competition today to find a way forward on the tricky issue of competition regulation in digital markets. Sorry, I'm not being able to change the slide. Why do we need first principles in competition regulation in digital markets? Mr. Jain covered this, but I'm just going to repeat. Broadly, it entails creating a framework of values that allow for holistic, enduring, and consistent outcomes. Why does this matter? The digital competition landscape today is rife with conflict. At the global level, there is a contradiction between new approaches to competition regulation that place digital markets at the center of their focus and existing competition law and practice. Digital markets are prompting a shift in regulatory approaches to competition regulation across the globe. Examples of the new approach are the Executive Order on Promotion of Competition in the American Economy, the EU Digital Markets Act, and the Consumer E-commerce Protection Rules that were recently released in India. There are three premises underpinning the shift. The first is the view that the ex post determinations take too long, the basis for this being who knows what kind of harm will take place by the time a decision is made. The next is a presumption that digital businesses are inherently driven to monopolize the spaces in which they operate due to the economic principles that undergird their operations, such as network effects. Third is the existing standards of competition determination, such as consumer welfare, are now obsolete because most services are free and businesses are information driven, so they innately proffer greater efficiency. The broader point here is that there's a political undercurrent driving the competition crackdown on tech. In America, it is driven by the pressure on the government to do something about big tech. In Europe, it is competition policy has long been guided by concerns surrounding protection of local industry players. India is similar to Europe in that sense, where a lot of action is on behalf or at the behest of national champions. And finally, China sees tech as a threat to its political hegemony, given the numbers that it wields. As we can see, the new approach lies in stark contrast to the existing approaches to competition regulation. To summarize, big may be big, but is big dominant? And is that dominance a problem? That is where the old world and the new world of competition regulation collide. In their efforts to do something about technology companies, new approach proponents fail to look at digital markets holistically. As the first point indicates, or as an example for the first point, Uber's entry into the Indian market prompted the reduction of many information asymmetries in the traditional transit businesses. Example, the Mumbai Kali Pili cabs now have their own app called Amchi Drive. It also stimulated the birth of Ola. Second, as long as information highways are neutral, consumers have effective choice. This is exemplified by our meeting today, which is being hosted on Zoom, even though Microsoft has Skype and Teams, Google has Meet, and Apple has FaceTime. Third, the third problem with the new approach is that there's no consideration about how regulation affects the competitiveness of legacy businesses. So there's no real impetus to deregulate, to enhance their competitiveness. So outcomes are the best determinants of a good or bad regulatory approach. And the US, which basically wrote the book on the old approach, has the best track record on innovation thus far. It has $4 trillion technology companies. Conversely, the EU's heavy-handed approach has hurt innovation in the territory. The most notable example is the blocking of the merger between Siemens and Alstom in 2019 that would have helped Europe compete more successfully against the state-owned Chinese Railway Rolling Stock Corporation. The US is now moving towards an EU style of competition regulation. So let's see what happens. Closer to home, we have the CCI, whose decisions in digital markets are often subjective and inconsistent, as it relies on qualitative factors for its assessments. In the case of taxi aggregators, for instance, in 3 separate cases involving similar parties, there are separate conclusions and 3 different ways in which demand-side substitutability has been applied to arrive at a decision on relevant markets. In the second column, you'll see that CCI concluded that there is no distinction between Uber and yellow taxis because of the widespread availability of the latter. Conversely, in the first column, it could distinguish between Kali Pilis, which are traditional taxis, radio taxis, which are services like Uber and Ola, and auto rickshaws. The inconsistency that we saw in relation to relevant markets can also be seen in cases related to predatory pricing, as is evident on this slide. So the graver problem here is that digital market cases are complex because they require an understanding of both technology as well as economic principles. Complexity is not something that non-specialized judicial fora deal well with. The conferral of jurisdiction over competition appeals to the NCLAT and the dissolution of the COMPAT means that there is no specialized scrutiny of regulatory decisions. And further, there is no real effective constitutional safeguard because the Supreme Court is unable, or non-specialized judicial fora are unable to grapple with the complexity of these cases. So we need first principles to guide these fora because we do not have the time to build their capacity. I will at this point say that out of all the regulators that look at competition in the country, the CCI is far more transparent and systematic in its approach. The aim here is not to criticize the CCI, rather it is to provide suggestions for improvement. So to summarize, we are moving towards a more inference-based and less data-driven determination mindset in the EU and the US. In India, the lack of specialization at the appellate level means lack of nuance in judgment. In the long term, this means more uncertainty and possible harms to innovation. So let's break this cycle with first principles. So where do we begin? So we thought we'd start with understanding or culling out first principles to understand harms to competition in digital markets. So, and US courts, given their extensive experience on this subject, makes sense that we take the principles that they have established over the years. So, possible harm versus actual harm. Competition decision makers should generally be very wary of addressing possible harm as opposed to actual harm. Some guidance in this regard can be found in US versus Microsoft, where the court said that the linkage between monopolization and network effects cannot be drawn as a problem on its own, but must be considered in the context of several preconditions. Similarly, in other cases involving taxi aggregators, courts have noted that holistic assessments of markets are warranted before making determinations. You must weigh both anti-competitive and pro-competitive effects. Similarly, US courts recommend a balanced approach to competition that determinations that weigh both sides equally. For instance, FRAND requirements for standard essential patents foment cooperative federalism amongst competing businesses. And if there are pro-competitive justifications for anti-competitive conduct or alleged anti-competitive conduct, it is incumbent on the plaintiff to rebut them. In India, sectoral regulators have a tendency to conflate service innovation with regulatory arbitrage. We've seen this with taxi aggregators, and we've seen it with online communication OTTs. I would like to conclude with the following. Even practitioners at the top of their game have a hard time predicting the trajectory of innovation market. So regulators should be more circumspect about their decisions. I'll leave you with the following. Samsung and HTC passed on Android before it pitched to Google. Tom Watson, the chairman of IBM, said that he thought that there was a world market for maybe 5 computers. Michael Dell said he'd shut Apple down and give the money back to the shareholders in 1997. And Bill Gates thought spam would be over by 2006. Thank you.
Thank you, ma'am, for that extremely comprehensive background to this discussion. As we proceed towards the actual panel discussion, let me take this opportunity to very briefly introduce today's panel. We are truly privileged to have with us Honorable Justice A.K. Sikri, former Justice at the Supreme Court of India. Justice Sikri is also the chairperson of this discussion. Welcome, sir. We are also very honored to have our speakers, Dr. Aruna Sharma, who is a member of the Digitization Committee, Reserve Bank of India, and former Secretary for the Government of India. Mr. Derek Ritzman, Director and Economic Expert at Economic Partners in Hong Kong. Dr. Shilpi Bhattacharya, Professor at the Jindal Global Law School. Ms. Himangani Dadwal, Partner at the Competition Practice at AZB and Partners. Mr. John Khigante, Vice President Public Policy at Disney Star India. Mohit Chaudhary, Junior Fellow at the Estia Center. And Mr. Vikas Kathuria, Fellow at the Observer Research Foundation. Welcome, everyone, and thank you for taking the time out to speak with us today. Today's discussion will be moderated by Mr. Vivan Sharan, the Secretary for the Estia Center. Over to you, Vivan.
Thank you, Richa. I think before we delve deeper into this discussion, which is so enriching already, may I call upon the chair, Justice Arjun Kumar Sikri, to please lay the context and the contours of our discussion. Sir, thank you so much for being here with us and really providing us with the vision for the over to you, sir.
Thank you, Ivan, and good evening to all of you and all those who are attending this webinar. Let me first congratulate Estia Center as well as Jindal University for organizing this webinar on such an important topic. Actually, it is a burning topic of the day, no doubt about it, because we have been discussing about the competition law and the way it is developing in India and the role which has been played by CCI from time to time, and it has come up for critical analysis in various fora. And today also in the beginning, the speakers earlier who laid the foundation to this particular program, today's event, have made certain comments about it. And but in the context of digital economy, I think it's a totally different, nuanced approach, which which is needed and on which we are still grappling with the various issues which are involved and which we are facing, and most of this which are already highlighted by earlier speakers, Mr. Gopal Jain and the girl Meghna, who gave such a beautiful presentation. What I feel is, yes, let me say at the outset, I agree with the one of the comments of Meghna as well, that look, in the hands of Supreme Court judges who are not expert in the field, and so therefore we need experts who can understand the intricacies of the issues which are involved. So in that sense, I may be a misfit here, who doesn't even today belong to Supreme Court, who's an ex-judge of the Supreme Court. Having said so, I would say, yes, I'm here to learn. And therefore, I should, in a way, thank SCS Center and Jindal University also for inviting me, because I think learning is one process which remains throughout your life, and one learns every day and every stage of the life. But what I feel is, from my perspective, if I see to it, of course, I would not be able to discuss the nitty-gritties of the issues which are involved here, and for which all the speakers are there. It's a panel of distinguished persons who are expert in this field, and they will throw light on the issues which have already been flagged and by the earlier speakers. But what I wanted to say was that, look, when we talk of competition law and its connect with the economy, first of all, there's always a deep-rooted and a very intimate connect with law and economics that has to be kept in mind. And it is, of course, kept in mind by the policymakers. It is kept in mind by the many times by the legislature also, but then the law enforcing agencies, those who enforce this, here in the context of Competition Act, it becomes the CCI, which is the regulator, and the judicial authorities, of course, the appellate authority as far as CCI is concerned, and then the Supreme Court. We have to see that, as I said, sorry for general remarks, that the relationship between the law and economics, that the most of, whenever we have to interpret certain laws, and when the situations come, of course, we have to interpret laws based on the well-recognized principles of interpretations, which talk of maybe the golden rule of literal interpretation, going up to the purposive interpretation, which is the latest fad as far as interpretation is concerned. But then in the whole process, while interpreting this law, what judicial authority is doing, whether I am interpreting in the manner which may have adverse effect on the economy of the nation, or economic activities, whether it is industrial or other economic activities of the private persons are concerned who are engaged in that, or it will have the boosting effect. So that is very, very important, is to be kept in mind. And this applies in full force insofar as competition law is concerned. Because competition law is a law in the realm of economy. It's not, because if I talk about the, as I said, the connect between the law and the economics, I may relate many other acts or many other statutes which may not have at least, ostensibly any connect, but still we may find such a relationship between law and economics. But when it comes to competition law, we don't have even to labor on this, because this is a law which is directly related to the economy. And because the competition law, or the law which is aimed at promoting the competition, is the objective of this law is to promote the economy, and that is stated in our Competition Act preamble as well, which says that support economic, this Competition Act supports economic development of the country. So therefore, when this is stated in the preamble, this is the objective. And when we apply the purposive interpretation, then it becomes the hallmark. And when we know, even before, of course, as Mr. Gopaljan has already traced the history of this, what we were and what was a legal regime before 1991, before we ushered into the era of globalization and liberalization. And we were in that license Raj and closed economy, etc. But the important thing which has happened, which he also highlighted, was that after opening up of the economies, the government of the day at that time, which continues even today, in almost now 30 years have passed from 1991 to 2021. Each successive government has gone ahead with the liberalization program. But what I'm saying is that when ushering into this era of the economic ease or giving freedom insofar as economic activity is concerned, what was most important, that although government regulation should not be there, but there should be some independent regulator who should be in a position to have some control or regulating that particular industry. And if you see in our, and it is the phenomena throughout the world, not only in India. And if you see in the Indian context, not only under the Competition Act, we have the regulator, which is the Competition Commission of India, which is the situation in almost all other enactments. When we talk of this telecom sector, we have TDSAT. When we talk of insurance sector, we have insurance regulator. When we talk of likewise, the banking, we have the regulator there in the form of RBI or other. So in almost all these fields, a freedom is given to the business or to the industry to do the business, which is their fundamental right under Article 19(1)(g) as well. But at the same time, in the interest of the economy, in the interest of the country, in the interest of the consumers, the regulator should be there to rein in that particular industry or that particular sector. And but now in this context, when I say on the one hand, this regulator, insofar as industry is concerned, and on the other hand, freedom of I mean, insofar as the economic activity is concerned, is to be given, that it becomes the duty or a fundamental role of the regulator to balance these two interests. And everybody knows that insofar as competition law is concerned, we have the we know that it promotes the economic interest of the country, and it is with the competition, say prices go down, quality is there, more innovative things come emerge. There's more spending on the research and development. And because of this competition, that so all these factors, and ultimately consumer gets benefit, which has various choices. As a very interesting example was given, that today, in spite of so many virtual forum open, we are on Zoom. So that is the choice which is exercised by the consumer. So they are also benefited. And if we go behind the philosophy of the our Competition Act, the three things which are majorly stated therein, that first is that it curbs the anti-competitive agreements, all those agreements which may have appreciable adverse effect on the competition within India. Second aspect which it takes into position is that those who are in a dominant position, those industries which are very large industries and in a dominant position, of course, there's no harm in acquiring a dominant position, but what is prohibited is the abuse of that dominant position. They should not abuse it in order to harm the economy or the consumer welfare. And as you know, the third is that yes, combinations, mergers, acquisitions, etc., they are again permitted, but they are regulated under Section 6 of the Act. Now, these are the three primary things. Now, how it comes when we, normal industry and other things which have been happening, and of course we have been grappling with the issues, as I said in the beginning, and there are many decisions of the CCI or of the Compact or even the Supreme Court which has come under criticism, or there is a critique maybe appreciated or critiqued, as Mr. Gopaljan rightly said, that one thing which CCI started in the beginning was very, very heavy penalties, whether that was good. I remember I was the author of one judgment which we gave, where we said that this 10% doesn't mean that it should be of that particular economic activity and not the entire, I don't know, Aruna ji is smiling whether she likes that judgment or not. But let me tell you, this judgment also, we had the economic effect of that particular provision in mind, where that was a case where the agreement which was entered into cartelization, etc., or the bidding which was done by entering into this cartelization, and they wanted to have kill the competition in the bidding process when the tenders were issued. But then that particular activity may have the effect of, say, what was involved was maybe 15 or 20 crores. And otherwise, that particular company had, this was one minuscule business or the unit, but the total turnover of the company from many other businesses was, say, 2,000 crores. And 10% of that comes to 200 crores, when here for 15 crore rupees only, they had entered into such a thing. So how you can impose a penalty of 200 crores for a transaction where the anti-competitive tactics or anti-competitive practice is adopted is only for 15 crores. And how much effect it would have been on the economy if you take 200 crores from that particular person or for that particular industry. So the economic interest was again in mind, and that purposive interpretation. I'm not on that. But what I'm saying is, and I'll come to this, I need not repeat that much, but then in the context of digitalization of the economy, and as Meghna has very beautifully in her various slides stated, so what is the impact of this digital economy, and when these players are coming forward and who are doing the business through digital means, and what is the policy which is taken, and why in these contexts the first principles, they become so important, because in the whole thing, otherwise also dehorse the competition law, which is more relevant for competition law, there has to be some definite approach on certain principles which are known to the individuals, to the industry, so that they know in what direction. She gave the examples that in three cases, there were three different outcomes in the inquiries conducted by CCI. So that leads to somewhat, the position which is in a way, suppose today somebody comes to me for an opinion. Now, going by this kind of approach of the CCI, what kind of opinion I can give? It becomes very difficult. So general principle also is that one is able to foresee that if this is the letter of law, what would be, and this is the activity, what is going to be the possible outcome. So this is very, very important. And in that context, why first principles become important from legal point of view also, and for the purpose of attaining the objective of the Competition Act also, they become very, very important and paramount. And I again say, and I may leave at that, because here in digital economy, which again Meghna had mentioned about that, and there are certain other examples which I had noted. I will not give now because we want to hear all the experts here. But the various authorities, they have led to some, various authorities means the judgments or the orders which are passed by the CCI, that how to define the relevant market. We are grappling with that, and that is why it led to different kinds of conclusions. And we have the case of RKG Hospitalities versus Oreval Stays in that matter, matrimony.com versus. So these are some of the cases which depict that. So in the whole process, what I feel is that a definite policy should be adopted by CCI and enforcer or regulator based on first principles which should be defined so that they are applied and so that we are able to move forward. Thank you very much.
Thank you, Justice. As I mentioned, your remarks will hopefully guide the rest of the discussion, and the discussion is structured to be a roundtable. So we don't intend it to be a series of lectures, but rather an interactive discussion where I hope that each of you can provoke each other, interrupt each other, interact with each other, and also the students that are watching, the questions will come to us and we'll raise them to you. So it's a more of a reflexive process, as Tanvi also mentioned, between academia and practitioners and so on. And just to pick up very quickly, sir, on your remark on the overall economic impact, I think this issue is heightened further by the fact that technology in itself is so horizontal in every dimension. So it is all pervasive. It impacts all industries. And in that light, I want to call on Dr. Derek Ritzman first, not only because he's a guest of ours in India here, albeit digitally, but he has a global vantage point sitting out of Hong Kong. And Dr. Ritzman, if I can just bring the discussion back to the center of the theme, which is that the roundtable is centered on the digital economy. Is the digital economy indeed unique? Why is it the subject of heightened attention if it's not unique? The corollary is the kinds of tools, the economic impact assessment tools that we have for the traditional economy, do they work for the digital? So for all speakers, let's keep the opening remarks to about 4 minutes, and that way we can have 2 or 3 rounds of interactive discussion. Over to you, Dr. Ritzman.
Absolutely. No, thank you. And good evening to everybody. And thank you to Jindal Global for inviting me again. This time it is digital. Previously, it's been on location in Delhi, which was wonderful. So thank you very much for inviting me to this very valuable seminar. So just to pick up on your point, is there something different about digital? So as a starting point, just because a market is digital doesn't mean that it's fundamentally, inherently different. I mean, digital markets are still markets. There's still the interactions of people who trade, exchange things, and so on. And so the fundamental principles of economics still apply to them. We don't, there's a temptation to think it's digital, it must be completely new and the old rules don't apply. And I don't think that's true. But digital markets do have some important special features that we have to pay attention to. And everybody so far has spoken about that additional complexity. And I agree with that. So the ideas of platforms and multi-sided markets aren't new. Credit cards and newspapers are also two-sided markets, but we see them much more commonly because digital technology makes it easy to create platforms. And platforms opens the door to something that people talk about, including Meghna, which is this idea of powerful network effects. Essentially this phenomenon where everybody congregates to the same platform because everybody else is doing the same. And so this is a legitimate issue as a source of market power, and we have to consider it. And it is something that it features more in digital markets than perhaps other markets. There is a discussion around the idea of the ability of platforms to control political and social conversations. And I think that's a legitimate discussion to have. But put it up against, that's only one part of the picture. You put that up against other features of digital markets, and there are some very powerful inherent offsetting economic forces in digital markets. People multi-home, people use different platforms at the same time. And that very substantially mitigates against market power from network effects. I have Visa's market power is substantially less because I can have both a MasterCard and an Amex card as well as a Visa in my wallet at the same time. And it's the same with Twitter. People can also use Facebook, Getter, Power, whatever the alternatives are. And including His Honor, Mr. Justice Sikri, have spoken about the importance of innovation. Innovation is a very powerful disruptive tool. Economists, I'm both a lawyer and an economist, but more of an economist. We speak about the economic growth engine of creative destruction, something new displacing the old. And that's a very powerful engine throughout history. And digital markets are especially highly innovative places. And that innovation brings, as has already been observed, and is perhaps a trivial observation, but a very important observation, brings very important social and economic goods. And regulation that seeks to counter that in a simplistic and clumsy way risks causing great harm by interrupting that innovative process.
Thank you, Dr. Ritzman, and thank you for keeping to the time so precisely. We will come back to you, and if I can turn over to Professor Shilpi Bhattacharya from GIGU. Dr. Bhattacharya, you've just written a paper this year called The Indian Competition Law and the Digital Markets, which I recommend that everyone read. Could I request you to kindly share some of your top high-level findings and discuss the positive aspects of the CCI's approach, as well as constructive suggestions for improvement, if any? And of course, digital markets as you have in the paper. Thank you.
Right, thanks. So in 4 minutes, that's going to be like a lot, but let me just lay it out very, very barely. And thank you for the recommendation to everyone to read my paper. But I think all the distinguished speakers before me have laid the foundation. So in terms of what we say in this paper, and this has been said by a number of scholars before as well, is that sort of the CCI, it's easy for us to sit and critique the CCI, but the CCI had to hit the ground running when it came to sort of enforcement in digital markets. And so we didn't really have a very strong jurisprudential or an economic foundation that could help us govern sort of enforcement in digital markets. Because sort of just around the time when the CCI started functioning, digital markets were exploding. So the CCI within a few years had to deal with all these complex issues. And the CCI has not had time to play catch up in terms of just building basic jurisprudential grounding for itself, which it could base its interventions in digital markets on. So of course, you need a separate approach to digital markets, and other speakers will talk about that, but you need to have a strong foundation in terms of sort of what are the goals that India's competition law wants to achieve, what is the purpose of enforcement, just very basic things which we are not very clear about even now. So we are not clear about, for instance, is consumer welfare the goal of Indian competition law? Do we need to tailor that to Indian markets? It's not very clear. Of course, the Supreme Court hasn't talked about that very clearly as well, and we've discussed that before. And then sort of, so now when we sort of talk about digital markets, what we say in our paper is that there is a move towards a greater sort of, it's a very sort of a reactionary approach that the CCI has taken to enforcement in digital markets. So the CCI has sort of in the Google case said that we must balance innovation with competition, and then in the recent interim order in the Make My Trip case, they've said that no, we must provide fair access to digital markets to all, right? So that's a very, very different goal. Providing fair access is a very different goal for competition law from sort of balancing innovation and ensuring innovation as the goal of competition law. So those are different goals. And if you want to achieve all those goals, then you need to think of a framework within which you will achieve those goals. So what we say in our paper, we're just looking at sort of the broad issues that CCI's decisional practice has brought out. And some of the things include things like using your prima facie review tool a little bit more carefully. So for instance, the CCI has just dismissed the OYO case at the prima facie stage when it was very clear that there was great that there was a need to investigate Oyo's dominance in the market for franchising services for budget hotels more carefully. So, so the CCI should maybe reconsider this approach of dismissing cases at the prima facie stage, and use that as a policy tool in digital markets to ensure that it's also learning more about these markets. If you're dismissing the case at the prima facie stage, you're also not investigating those markets carefully and learning more. Of course, you have the market study tool, but have you really used it effectively? So that's also like another thing. I know my 4 minutes are up, so I can take this up further sort of in subsequent discussion as well.
Thank you, Professor. One of the issues that you've raised, I think we see across the regulatory sphere, is this tension between access and choice and innovation. Several regulators have grappled with this in the Indian context. And if I can turn to Aruna ma'am, it also closely relates to how we see the role of platforms, which are increasingly labeled as utilities in the West, which is having a change of heart in the US and also in European Union. There is significant academic debate around whether to regulate digital platforms as utilities. And some argue that the positioning of large tech platforms in key information markets bears close resemblance held by utility operators in their respective domains. So is there a problem, ma'am, with using a deterministic lens to say that the problems of telecom, railroads, etc., are now being replicated in digital markets?
Thank you. Thank you so much for giving me this opportunity, and nice listening to the previous speakers and presentation. I will focus very, very clearly as to, because we are at a formulation stage for the laws wherever the digital transactions or digital markets are growing much faster and replacing the traditional understanding of the markets. And US and EU, they might have taken the first steps forwards, but there are major lacunae into it. So I'd like to make a mention. So I would like to start off with the basics, that if we talk of first principles of governance, we have to understand that CCI, what the preamble Justice Sikri very rightly said, is it to facilitate or to regulate? This understanding has to come out absolutely clear when we are talking about it, that if our intention is to facilitate the business when we are going ahead, then the look has to be entirely different. And the digital is markets is whether we treat it as a platform or we treat it as a utility. Because many a times, just because now today digital is growing in size and more information is available for the market, or it is modern mechanisms for dissemination, are we treating it as a product in itself? And that is the basic mistake which is happening today when we are handling into and talking about the digital market as we are going ahead. So therefore, in any framing of rules or laws, it is very important, including the interpretation, to have this distinction that digital, whether we treat it as a platform or we treat it as a product, and therefore does utilities apply to it, or it does not apply to many of the things which we have shifted into the digital way of transactions. So if we are using only the payment, or if we are using an e-commerce as a platform, now e-commerce is just a digital platform, whether you walk into a shop and buy or whether you buy it online. So therefore it has to be very careful when we are dealing these things and while framing the laws. And if you look at a utility, it started off with, very rightly said by the previous speakers, with the electricity distribution networks and consumer utilities. And then, of course, it shifted to telecom, and the AGR has created quite a mess in telecom. We are all aware about it. So if you look at it, what it requires is a total satisfaction. We are talking about it. So platform will provide the essential infrastructure, the social interaction to the e-platform, and therefore now social media cannot be at the same place as a marketplace, or it cannot be at the same place as an aggregator. So this distinguishing is very important while we are formulating or while we are interpreting, and it is to be regulated differently by understanding the nuances which are getting into it. So if you look at it, what we are getting into is that we are thinking of presuming that if you are a big player, the monopoly is inbuilt. The whole beauty is lying into the access part of it. So have we gained access? Now, anybody which has an internet is gaining an access to a huge market which is available. It is gaining an access to make a digital payment mechanisms. It is gaining an access to collect the information or collect the information. But where does the competition comes? The Visa and MasterCard, the POS machines, if any one of you is aware about it, the POS machines used to accept only the Visa and the MasterCard. It was not accepting the RuPay card which the India introduced. Then yes, then you are preventing an access of a particular product, and that is what created a problem, and that's why the correction is needed. But then by saying that no, we don't have A or B cards and we'll have only C cards in a particular geographical boundary is not what is being headed at in the Competition Commission or as a first principle. Again, if I say it very, very clearly here, that it is very important that while we are trading into this, we have to be agnostic to the competition. Now, if you look at the today Economic Times again talked about the PABG, that is the payment aggregator and the payment gateways. We are saying you cannot store an information. Now, are we, again the question comes, are we putting a hat of a mere regulator without understanding how the business works and hampering the facilitation? So every time if you accept by a regulator that you feed your details of your debit card or credit card, then what happens to your standing instructions? It goes away. And every time you feed, you are exposing it more and more to the cyber hacks, because now it is going to transact into multiple digital channels. Whereas once you feed it, it is locked. It is only the CVV which you are giving, and that's it, and then your transactions are through. So this example I'm trying to give you very, very clearly to understand the different role. We have to first of all understand what a digital business is, separate it from understanding of platform and utility. I will touch upon what US and EU has done, where the digital market governance, you talk it as a competition related themes, whereas European Union treated it as a business trading practice. Right. The France was treating it as a fairness obligation, and it focused more on the transparency, and therefore it moved against antitrust with the Google. Now, this is the wordings which we have to understand, that the Competition Commission's role very, very clearly comes as a regulator is to ensure the distinction in the marketing and the transparency, whether it is adopting, whether it is giving access and level playing field. Otherwise, then we have no business. Otherwise, we will be hampering the access, will be hampering the innovation in a completely different way. And this mess has already come in the e-commerce arena, where you find the multiple departments have come. So whether it is a commerce department, whether it is in IT Act, whether it is the Consumer Affairs Department, recent draft rules which has come, because you are confusing between a platform and the ownership, right? The ownership is whether back-end ownership you have ownership in other businesses, whether you are doing the entire value chain, whether you have an ownership, whether it should be 2% if it's a related party, or it should be 24%, what came in the December press release. So December 18 press release. So these are the kind of problems you will end up battling, and subject to then interpretations and hampering the growth. Because if you put consumer as a center stage, the future is IoT, future is AI, future is machine learning and related cyber issues. So if you put consumer there, then all these platforms, the choice is widened. The consumer will be the ultimate master. It will get it at a much effective role. It will move at a much effective role. And therefore, when you are looking into these aspects, it is very important that while framing the law and therefore leading to interpretation and therefore leading to the competition, the first principle is to clearly distinguish our understanding between what is a platform, what is a market, what is a utility, and whether access is a center stage and whether transparency is a center stage. So I think I'll stop at this point because I think I will be covering my 4 minutes into this, and then of course one can come back if there are more questions. Thank you.
The objective of this discussion is also to hear voices from industry and not just discussion between policymakers and academics. So we have John Kyangte here from Disney. And John, I think to ma'am's point, one of the fundamental things that we need to think about is not only the differences, functional or otherwise, between products, platforms, and so on, but also really how digital markets work. And with an inside view, as a major market operator, you have to unbundle for us what are the different growth dynamics, what are the kinds of incentives needed for firms to do well in digital markets, and therefore what are the kinds of interventions that are perhaps best avoided. Because one of the ways in which many of us, I think, have chosen our careers, and there's an analog, maybe it's a tenuous one, is to decide on what we don't want. And perhaps that's the one way to start setting principles. So John, over to you on how you feel markets work and what is therefore best avoided.
Yeah, thanks, Vivan. Good evening, everyone. I think, Vivan, I'm faced with a good problem because we've had good speakers before me, and I've noted down some of the comments that have been, remarks that have been made. So coming to your question, I think, and I want to touch upon Mr. Gopal Jain's opening remarks about saying that a market-driven economy and strengthening of markets. I think if I look back, the imperatives are very different from, let's say, 1991, when we faced the economic crisis, and the imperative today. But as Derek said, I think the principles of the markets, whether it's digital market or physical market, they more or less remain the same. And the point I want to come to when you talk about incentive, I think the key foundation for a market to be formed and to function is the incentive that's created by the markets. And this is often referred to as the invisible hand. And when I look back, some of the the policies or regulations across markets, I think there is some sort of apprehension from allowing those free market forces to work. And what happens is that because you've not allowed, so you've said, okay, market-driven reforms, but then you layer, before the markets actually function, you put a regulation on top of it. And once you realize that the regulations don't work, you say that the markets there's a market failure. And what happens is that you impose another regulation on top of it. So you have layered regulation over the other. And eventually we've never seen, I think, a true market in that sense, as economists would call it, work in our country. I think there are some sectors that are very close to where you've had a free market play. So I think the incentive is important, and the incentive is created on the expectation of the reward that I'm going to get. And that reward, speaking from a let's say movie and film media entertainment industry, depends on the kind of protection that I am going to get for the work that I have done. And so the incentive chain is, so you have the incentive which is dependent on your rewards, and your rewards are somehow dependent on the regulatory regime that's there. So what happens is that in India, before the regulation, the markets are actually formed and allowed to function, regulation steps in and then sort of comes in the way of the incentive. There was Meghna touched upon innovation. Justice Sigri touched upon, I think, balance, the word, and that's the note I put down. I think it's very important today, I think, to set these first principles for competition in digital markets. And in India, I think when you look at it purely from an economic lens, it becomes very simple. But when you have other factors like politics and all of that coming into play, it becomes difficult. So at some point, as a society, as a country, we have to balance it. But having that first principle always helps in understanding how much we've deviated from the first principles. So I'll just limit my initial remarks on that. And just before Vivan, I think when I look at CCI, and I think they've done a decent job. I would say that they have done a decent job in managing what Derek said, creative destruction, retaining competition, despite the sort of creative destruction that we've seen triggered by innovations in the country. One thing I would want to say is that, having done a lot of market studies myself, the problem in India is always with data. And most of the time, when you're doing a study, a case-by-case study, you work on almost like, 60 or 50% of the data that you need. So despite these challenges, I think CCI has done a relatively good job. But from an aspirational point of view, for India to be able to set the precedence for the rest of the world, I think there is much to be improved upon. Thank you.
Thank you. If I could turn to you, Vikas, John left on the note of market studies, and there is, of course, the CCI is, to its credit, engaging on many more of these. There's an e-commerce study, there's a telecom study that are fairly recent. And there are also suggestions there on the kinds of ex post and ex ante measures that are required. Some are sort of prescriptive, some are suggestive, some are specific, some are generic. So I just want you to weigh in, and there's been too much, I think, consensus in the room. So maybe you can weigh in from your perspective on the intersection between ex ante competition and innovation regulation. What is, for instance, what is it that regulators must consider while balancing the two? Do you actually differ from the view in the room in terms of the need for guided market interventions?
Well, thank you, Vivan. I will be quick. So my task has been made easy by John. Thanks for bringing up incentive. Human mind invariably responds to incentive. So an innovation definitely does require incentive. So if you have too many people competing for a product, who you hardly have any incentives, you do hardly have any resources you can put it into innovation. And if you have too few, once again, you do not have any incentive, you do not have push. In the economic terms, that is why we get the relationship between competition and innovation as an inverted U-shaped structure. So making it very simple, here in digital markets, there is a dire need for intervention to make sure there is innovation. Because if you see, there are hardly any players, thanks to network effects, economies of scale and scope in data, lock-in effects in data. That is why there is a need for intervention. We could not understand it in the past. If you look at the Facebook, WhatsApp merger, Facebook, Instagram, we just could not understand that these small entities, WhatsApp or Instagram, in the due course of time could become big enough to compete with these giants. And, we did make mistakes. The Lear report in the UK points out to 4 such mergers where we got the concept of consumer welfare wrong. We did make mistakes. So I think by now it's very much clear that the innovation depends on competition. There should be optimal competition. Hence, there should be some sort of intervention. But this design of regulatory tool is very difficult. It's very intricate. You have to balance the short term and the long term. And here I completely agree with John that if you take away the incentives, the market would be stifled so far as innovation is concerned, because these are fast-moving market. And to give you an example from the content, if you put multiple layers of regulation, then the players do not have the right kind of incentive. Here, there is no perhaps case for regulation if there is no market failure as such. So hence, I believe that the relationship between ex ante regulation and innovation is very intricate. I give you one example from the telecommunication industry, because that is the most immediate example if you're talking about regulation of the tech digital economy. See, Martin Cave, he came up with this example, with this idea of letter of investment, where you burn the letter as you give access. So this pushes the new entrant to innovate. So this was some sort of a legal solution somebody came up with. Likewise, we are also coming up with some sort of techno-legal solutions. Here I'm referring to the DAPA model. Thankfully, Aruna ma'am is here. So I would like her to develop upon it, the account aggregator system that RBI has come up to ensure that data is not locked into silos and everybody gets access to it. So here I would just stop, and maybe I can take up questions later.
Thank you, Vikas. Lots of questions. We will come back to you. Also, we're now starting to receive some questions from the audience, which I will raise to you esteemed panelists. If I can turn to you, Himangini, you've had a busy day and I hope you've sort of refreshed, but given your extensive experience in competition law in India, maybe you can share some examples about the broader experience of preemptive competition regulation in other sectors. What can we draw from experiences of tested or untested ex-ante regulation? Because Vikas alluded to the fact that sometimes you need ex-ante measures to actually make sure there is enough competition in a market. And you may have seen this across traditional and new spaces. So over to you, Himangini.
No, thanks, Vivan, and good evening to everyone, Justice Sikri, fellow panelists, and all of those who have tuned in on a Friday evening to discuss competition, regulation, and tech markets. Honestly, being a competition practitioner, one of the good things about that is that we do see markets, or we tend to get familiar with different markets when we're dealing with different cases. And certainly no two markets ever have the same features. And I think there, I agree entirely with Derek, is that, while the digital markets certainly exhibit some peculiarities, I think, there's a lot of rhetoric about, whether we need ex-ante regulation for digital markets, because it's a completely new beast. And I think there we might be oversimplifying it or overstating it when we say that the digital markets cannot be regulated under the laws that we have today. So just to set out, a little bit, I can't speak. I know for a fact that, there are other jurisdictions, the EU, is following the precautionary antitrust principle in order to come up with, ex-ante regulations. But it might not, and I think there are certain pitfalls to any ex-ante regulation. And especially when we're talking about something like digital markets, where I think one of the nuances or the peculiarities of digital markets is that technology today is not going to be the same tomorrow. And then naturally, when you're trying to develop laws and regulations to govern something that changes as fast as technology does, then you're always in the fear of over-regulating, certainly, and then it resulting in false positives where regulation is actually not obtained the objective that it was meant to, which was to, and especially under the Competition Act, which is to enhance competition, but has instead taken away the incentives, taken away the competitive space that existed prior to its regulation. So I think when one looks, we don't know what ex-ante regulation in terms of competition principles would look like. I think there's a movement towards that. There is discussion towards that. Any laws that have come in are too new for it to see what kind of effect it will have. But I think there are a couple of things that one needs to be a little careful of. So, I mean, I think there's a good paper by Aurelian Portuguese on the precautionary principle. And what he says is that, the principle of precautionary antitrust is based on 4 principles, which is you're firstly reversing the burden of proof. There's uncertainty, there's a lack of harm, and there's an urgency to regulate. And all of these 4 factors don't really make for good law. Certainly, when you don't have enough, when everything is moving as fast as it is currently, and you don't have either the tools or the knowledge to understand what you're regulating, the markets that you're regulating, and you're in a hurry to over-regulate because there is, the back of your mind, there's too much power in the hands of too few, something that, we've been living with. I mean, I think when the Competition Act was first drafted, there was a reason why we didn't say a monopoly we moved away from the MRTP regime to the Competition Act, which said big is not bad, but what you do with big can be bad, and let's examine that. What ex-ante regulation does is that takes away that prerogative. You're already setting, and especially when you're looking across sectors, and in the digital markets where you need network effects in order for a particular platform to be effective, you need to have enough participants on both sides in order for that market to be effective. It's not necessarily the case that big will always be bad. There is a case that
big will certainly generate certain efficiencies, which will need to be dealt with. And it's not to say that there cannot be harms, but is ex ante regulation really the tool with which one should govern digital markets? I, for one, and I think I agree with almost everyone here, is that I don't think there is a right, clear answer at this stage. We certainly need more evidence. Absent an evidentiary based approach to determine how we're going to regulate, you really risk coming up with false positives, and not only a detriment to one or two companies in the market, but really to entire sectors, especially as the economy entirely is moving towards a digital economy. So I won't take too much time right now, but if there are any specific questions sort of that come up in either in a particular case context or the reasoning behind the CC, I'd be happy to take them.
Thank you, Himangiri. If I can finally turn to Mohit, who, for everyone's information, is also authoring a paper for the center on a question that we haven't grappled with fully today, on relevant markets and the kinds of principles that can be used to determine those. This is at the center of the discussion, for instance, as of this week, between the FTC and courts in the US around the case on Facebook. And, for instance, the FTC has qualified the market that Facebook is part of as the personal communications applications market. And for me, I am one person in this room, at least, who feels that drawing the boundaries as far as what personal communications is a fairly tough job. And is it limited to communications with people or don't know? I think COVID has also sort of changed many assumptions. People talk perhaps more to machines today than they ever did in the past, and so on and so forth. So Mohit, this is a tough job for regulators, let alone civil society that sometimes doesn't quite have the exposure to the everyday dynamics of technology markets. But how are you taking a crack at this? Can you share that with this forum?
Thanks for the introduction, Vivan. I'd also like to thank the organizers of today's roundtable for giving me an opportunity to present my research, and to all the other panelists for their excellent remarks so far. As Vivan mentioned, I'm authoring a paper on relevant market determination, which is usually the first step in several antitrust inquiries. Specifically, I'm looking to answer two questions. The first, why is it necessary to revisit principles of relevant market determination in the context of digital platforms? And second, which is what Vivan alluded to, how are regulators going about this tough job in other jurisdictions as well as in India? So with regards to the first question, identifying principles for relevant market determination in cases that involve digital markets is necessary for two reasons. First is that the current principles have been determined keeping in mind one-sided markets. As Professor Ritzman alluded to earlier, most digital platforms today operate as multi-sided markets in that they serve two or more distinct consumer groups. As a result, there are certain peculiarities which such markets display, which other panelists have referred to in terms of indirect network effects, multi-homing, single homing, zero price, etc. These characteristics have an important impact on substitutability, and a failure to account for their existence can lead to incomplete assessments of competitive constraints that a product or service faces. Dr. Bhattacharya, I think in her previous research, has noted that the CCI in cases involving Oyo, Make My Trip, and Google has failed to consider the multi-sided nature of markets and has considered only one side, which has led to incomplete assessments of the competitive constraints that firms operating in digital markets face. The second reason, which I think Megha illustrated really well in her presentation, was that the CCI's market determinations have largely been inconsistent. For example, if you consider how it has differentiated between online markets and offline markets as to whether they form part of the same relevant market or they are distinct relevant markets altogether, you can clearly see that in initial cases, it was that these formed distinct delivery channels within the same relevant markets, while in recent decisions, it has shifted to holding them as being distinct relevant markets without providing the necessary justification or evidentiary value for the same. The failure to adopt a consistent evidence-based approach obviously is problematic from a legal and an economic perspective. And this is where it becomes important for us to frame first principles that will guide the CCI's determination of relevant markets in future cases that are likely to come up. quickly now coming to what practices there are in other jurisdictions. In my research, I observed two broad trends. The first trend is that competition authorities in most countries are now beginning to explicitly recognize that markets do function in multi-sided environments and that indirect network effects play a role. And this is usually followed by a determination of whether a single market needs to be considered spanning both sides, or two distinct relevant markets need to be considered. The approaches that have been adopted, of course, differ. For example, the US and UK have adopted approaches which focus on the typology or the nature of the platform, where they've differentiated between transaction and non-transactional platforms. Whereas other jurisdictions such as Brazil have made this analysis just by studying the strength, direction, and existence of indirect network effects on a case-by-case basis. The second trend that is observable is that there is a move away from quantitative metrics to analyze competition in markets, specifically in zero-price markets. Instead of relying on tests like the SSNIP test, which has been traditionally used in one-sided markets to determine substitutability, regulators are turning to other considerations such as qualitative considerations. Of course, the use of qualitative considerations needs to be matched with evidentiary value, without which they can lead to further inconsistency and discretion in relevant market determination. So just to conclude and recap, the two broad principles that are visible are, firstly, competition authorities should account for the existence of multiple sides, their interdependence, as well as network effects in determining competitive constraints on products. And quantitative metrics need to either be modified or done away with altogether in markets which involve zero prices and multiple sides. Thank you.
Dr. Ritzman, I want to now throw the ball back at you with a quote from Mark Zuckerberg to his CFO in this ongoing investigation. And this is on Instagram, and I found this particularly useful. He states that, and this is on the relevant markets point, which I want to continue a little bit with you. And there's so much, so many of the questions that are coming our way relate to big tech. So we have to take that head on. He states that one thing, and this is in 2012, one thing that may make, and this is in brackets, neutralizing a potential competitor, maybe this is the FTC's fill in the blanks, more reasonable here is that there are network effects around social products and a finite number of different social mechanics to invent. I repeat, a finite number of different social mechanics to invent. This is vis-a-vis Instagram, a potential merger or acquisition. And once someone wins at a specific mechanic, it is difficult for others to supplant them without doing something different. So my question to you, Dr. Ritzman, is this: are we looking at a digital future where several of the large platforms are actually in unique markets? So they're not necessarily operating in markets where there are direct competitors, and they may never be able to, because they are in an environment of technological innovation where once you hack a particular growth trajectory, and we saw this with TikTok, right? TikTok has overtaken so many of the social media majors, and it's taken the world by storm globally. And how did it do that? It had a very specific social media mechanic in its instance, which worked. Maybe tomorrow in the AR, VR world, something else works. So are we looking at these in some instances, at least, as far as social networks are concerned, for instance, very specific markets of one? And what does that mean for us?
Sure. One thing I would say is one should, just from a market definition perspective, one should never define markets according to the supplier, because even if you have a market where there happens to be one supplier, they can always be displaced. Potential competition matters, and yes, network effects, the fact that your friends are all on the same platform and therefore you are sticky to that platform and they are sticky to it at the same time, that is a significant issue, and we have to think about it. But you talked about TikTok 2 years ago. Where was it? We're speaking now on Zoom. At the beginning of 2020, I think none of us, probably, or few of us, had heard of Zoom, and then it took the world by storm. And the fact that it can means that somebody else can too. Now, that is this idea of network effects, and as Hemangiti described also extremely well, a successful platform is one that connects a lot of people, and that does create that stickiness. But a successful, and that does make it a little more difficult for platforms to coexist. But we see that these platforms can come and go when somebody like Zoom comes up with a better way for people to speak to each other in online conferences or classrooms by technological innovation. I did a class, an online seminar by Skype the other day, and I love Skype for certain purposes. But for what we're doing now, it's far behind Zoom. And next year, somebody will invent something better than Zoom, maybe. So I think first of all, I would never define something according to the supplier, because nobody is the only supplier by definition in a market. It is the thing that they are supplying that you do. And secondly, this idea of creative destruction, the fact that somebody comes along and can displace you, also means that we shouldn't do that, and also speaks about actually that connects to the idea of utilities regulation, which I'm very, very wary of in this context, but that's for another discussion. So I'll just cut that short for the moment.
Thank you for that clarity of thought. If I can turn to you, Professor Bhattacharya, we have several questions, as I mentioned. Now let me start lobbing them at you. This is probably from one of your students. Urbi Sinha asks, if the privacy bill is implemented, will it have an effect on how anti-competitive behavior in digital economy is determined? Especially when it comes to privacy related concerns. And I'm asking you this obviously because you've touched on this in your paper, these thematic intersections and, how we should think about first principles to solve them, or to solve cases that lie at these intersections.
Yes, thank you so much. But also just quickly on market definition, because that's also like a very interesting question. I just wanted to sort of just maybe provoke a little bit more discussion on that. Just to say that sort of market definition is such a complex question in digital markets. And of course, developing first principles for something as complex as market definition in terms of like how our platforms competitively constrained needs a much more nuanced sort of approach. So I feel that in terms of like, I really don't know how any regulator can do this, but all I would say is that in terms of an approach to market definition in digital markets, we cannot have any bright line rules that will just make sort of, we cannot be reductionist about this. So we have to keep an open mind, and we have to sort of think of the broader principles at play here, which is that how are platforms competitively constrained, who are the players competitively constraining them, but at the same time keep an open mind in terms of how we want to, and maybe also just have like looser boundaries to market definition, but avoid sort of having very, I feel that it's an area of law where we need to be more careful in terms of how we approach being very reductionist in our views in terms of, okay, we cannot define, or we can define markets in certain ways. I think in digital markets, we have to be much more careful in terms of how we define, because it's very, very complex, and there will not be a one size fits all approach, I think, to defining any kind of platforms. But having said that, on the issue of privacy, yes, so that you're right, we addressed that in our paper, and what we said in our paper was that the CCI has sort of given this prima facie order where it's going to investigate WhatsApp's change of privacy policy. And of course, this has raised a can of worms in terms of, is CCI the proper authority to do this? And the CCI has been very careful to say that this is an issue of consumer choice, in the sense that this is an issue of how WhatsApp was able to force consumers to shift, right? Because it has the market power to do so. And if this is a sign of abuse of market power by WhatsApp, then it becomes an issue for the CCI to investigate. But of course, and so the CCI has said very clearly that in this sense, it is looking at privacy from the perspective of its impact on markets, rather than privacy in the way that sort of the bill might envisage. So it's kind of like saying that, okay, there is sort of a difference between sort of how we investigate sort of of issues, because privacy is not the central issue here. The central issue is of sort of how is this market structured, and sort of privacy is ancillary to that central issue. But at the same time, the CCI is able to do this because we don't have a privacy regulator in place. So we're not really sure how a privacy regulator might view the CCI's sort of intervention in these kind of issues once it does, once it is established. And then I think the CCI will have to be careful, but also to say that the Supreme Court's judgment in terms of CCI, in terms of sectoral overlaps, was very specific to TRI, and of course there the law is much more sort of TRI has much more capacity, right, in terms much more sort of ability to regulate on these issues. But the privacy regulator, once it is established, will not have that same kind of overlap with competition concerns in that sense. And so maybe the Supreme Court's judgment doesn't apply in that same way. So we have to wait and see sort of how sort of even the courts view these kind of overlaps, because I don't think that judgment would be applicable to every kind of sectoral overlap.
Thank you. If I can turn to you, Aruna ji, the several questions on big tech. For instance, Om Ram asks, in digital markets, don't you think big giants have created entry barriers which do not seem illegal, which do not seem legal prima facie? I think he means your comments. And similarly, Samrat Chakrabarti, fifth-year student at SLS Pune, asks, big tech like Google and Amazon have been involved in multiple competition lawsuits across jurisdictions, resulting in heavy fines. Doesn't this necessitate more of a concern in India, and so on and so forth? And just coming back to now, I think because there's so much attention on platforms, and you mentioned the term gatekeepers or gatekeeping behavior. Now, in relation to that, can we also think of potential solutions, assuming that there is gatekeeping behavior in certain digital markets? What are the kinds of solutions that you would recommend? And it's also interesting, ma'am, to me that we have, I think, gatekeepers in almost every segment of, the traditional markets in India. These are intermediaries who intermediate between us for almost everything. And sometimes those don't become concerns because there are inherent market dynamics that account for those, or there are administrative checks and balances. So Aruna ji, just on this question, an extension of what you were saying earlier about utilities, but how do you move towards a solution? Or what is a way in which India should start? Because obviously a lot of people are asking these questions. So our political leaders will also ask these questions. And I think that's the democratic process, which requires an academic and a regulatory administrative response.
Right. So I'll take all the three questions one after the other. It talks about always the first entry advantage will be there. But I must say that digital platforms provide a quick distraction, or sort of it breaks out the IPRs. So what you have in a traditional market, the first entry advantage takes a very long time for a new entrant to come. Like somebody gave a very beautiful example that you had a TikTok and now you have a Zoom. So in the sense, so the first entry advantage may be there, but somebody better has come. And if you look at the big names which has come, which has creating this multiple platforms and gone, they are constantly innovating. That constant innovation is their basic thing for the survival for a longer time in the market. And that's how they are creating these entry barriers at a different levels with the new kinds of innovations. The old innovations have been taken over by the other players. And that's how you are having multiple players coming. The second question was talking about this Google and others across the globe getting a lot of fines and everything. So you please understand that these are the platform which has come with the information and information availability. The mergers and acquisitions has created whether the data privacy is going to take place or the data privacy is going to navigate between different platforms when it is moving around, like the Facebook thing or with the WhatsApp. So now these are the points of worries where the focus has to come up on a really fine tuning as to how we are going to go about the data privacy laws. See, we must understand, somebody very rightly said that data availability is a problem. Data is meant for analytics. Otherwise, why the hell we are taking the data? So it is very important that you have a robust analytics. You have a better technology to use that data for the consumer betterment, for better ease, for better competitive pricing as we are moving ahead. And that is going to make a difference. So data is for competitive benefits. It is for efficiency. It is for consumer advantage. It is for edge analytics. So these are the things which are going to come up very, very sound, and nobody can stop it, right? So no law in the world is able to stop this when we are moving ahead. What is important is that whether somebody is becoming exploitative into the whole process. And your third question, that when we are talking of the gatekeeping, what could be the solutions for this? It is very important, by sounding repetitive, that while we are framing these laws, including US, EU, and India, we have to clearly distinguish what we mean by utility, whether utility regulation copy paste we are going to apply to the digital mode of functioning. Answer is no, because every digital platform is not a utility. Somewhere it is just a change of the way the transaction is done. So whether it is a financial transaction, whether it is the marketing processing you are doing in the market, so it is just a change of mode. So that distinction is very important while we are drafting it. Then it is very, very important that across the value chain, digital transformation is taking place. So where do we want to put this regulator? Do we want to put in the entire value chain, or do we want to put into a section of the entire value chain? So this is also becoming very important, because that is creating a lot of confusion where we are moving ahead. And loosely using digital utilities word, I think Facebook had a foot in a mouth disease when they first time used the word utilities for themselves. So you have to understand that whether it is the English word of utilization of digital for businesses as an effective tool, or whether it is the utility from the economic definition when we want to put a regulator for it, right? So that distinction has to come up. So as a solution, we will have to define that we don't have to capture the entire value chain. We have to define in that value chain of the digital mode in which we are shifting as to where we go ahead on this. And two more points I'd like to make, that when you're working on the online platform, we have to be very clear that it is not a utility. It is just a tool. So if we are treating it as a tool, we have to allow its expansion. We have to allow the innovation. We have to allow the improvement into it. And we should not become a hurdle. And therefore, I use the word facilitator. So therefore, it is not like regulating merger, acquisitions, and equal playing fields and everything. So here it will require an entirely different treatment that we have to allow, because it is allowing the reach, it is allowing the access, it is allowing the new mode of functioning. It is creating a very robust real-time data. It is available for analytics. So the focus has to be that we're only answering three questions, that whether it is killing the competition by creating somebody having a monopoly. That is where we have to have a fair play of multiple players, which even in the traditional method in India, we have killed the in telecom number of players. So we are actually heading to bipolar. So that we should not allow it to happen in the digital platforms. One, that is very important in the solution. Second, in the value chain as to where we want to go, we have to take it very, very clearly. And third, we have to be very clear that while we are defining this entire modus of the entire new way of functioning through the digital platforms, we allow innovation. And by regulation, too much of regulation is not needed. The consumer, if it is having a choice, it is getting a better choice, a better pricing. I think no regulator is needed. That is should be the sounding principle.
Ma'am. John, let me turn this dichotomy.
I hope I responded to all of your questions, right?
Absolutely, ma'am. And if there was such definitive certainty in our administration overall, it would really guide us towards optimal outcomes. John, if I can, just taking from ma'am's point on these difficult questions around efficiency versus killing competition. Now, I think it's also important to understand which competition is being killed and how. And one of the core functions of digitalization is disintermediation, which creates greater efficiency. We like this principle when it comes to, say, the unified payments interface, right? We are disintermediating traditional banking and finance channels. So how do we come to dislike it in other spaces where the same effect is taking place? Or is there a more nuanced way to understand what kind of disintermediation is good, what is bad? And so just coming back on this question of which competition is being killed and how that impacts, therefore, our understanding of whether you need to regulate upwards, downwards, have ex-ante principles or greater scrutiny. John, any light on these complex issues from your perspective?
I don't have a definitive answer, Vivan, but I'll try and attempt the respond to you. I think when you think of, and coming back to innovation, innovation does create destruction. It destroys the old technology or old business models. And what happens, and broadly, this is my observation, in any industry, traditional industry, it's almost the middleman that sort of profits out of the system. And what digital technology has done is that it's disintermediating those middlemen and removing the inefficiencies. Now, the way I see it is that the ones who were profiteering out of that inefficiencies are then going to the regulators and the policymakers and asking for a level playing field, right? So I think what in that process, what they are basically wanting to do is sort of kill the sort of perceived competition or emerging competition, that's something which they believe a new market is emerging, or maybe a more efficient market is emerging that is going to eventually eat up their profit. So I think, so therefore, if you ask me, this intermediation creates new market, it creates new competitive forces. And so when you look at in terms of, again, first principles, I think with respect to the new digital market, I think we need to ensure that the incentives are intact and that the market continues to innovate. Now, when you come to the people, the middlemen who have sort of asked for the level playing field, if it's regulation that is making them inefficient, then I think a reform in that sector is imminent from that perspective. And just to give you an example, right, you have your video on demand that's growing at a huge rate year on year, and you have a television industry, right? Now, more often you would see people who, mostly the middlemen, asking for some sort of a level playing field. Now, instead of leveling up the regulations on the video on demand industry, I think the regulator should sort of look at, say, how do I reform the traditional regulations and make them more competitive? So I think, and also I think as a regulator, I think they need to sit back and say, okay, what are the primary objectives of my regulation? And how do I reform that regulation to make it more competitive? I hope I've answered your question. And very quickly, I just want to, and since I think this would be my last, since we're about to close, I think just wanted to make a small comment with respect to data sharing. I think, and coming from a copyright industry, I think it's important to understand the incentive versus excess. Any excess takes away incentives. So where do you balance, right? And as a country, I think we need to ask ourselves, why is IP as a percentage of our GDP too low? And whereas America, it is at about 7%. So we've relied too much, I think, on excess. And in the process, we sort of kill that incentive to create. So I think as we look forward, I think it'll be very important to see where we strike that right balance for the future of India. Thank you.
Thank you, John. Vikas, if I can turn to you, and this is sort of a synthesis of several questions that have been posed. What sort of evidence can ex-ante regimes be based on? Is there a case to be made for some sort of a regulatory sandboxing of certain digital markets to understand, again, the mechanics, dynamics, etc., before thinking about ex-ante principles? Or do you think that there are some markets where you don't need to wait for that and you can already start to envision what these principles may be?
Vivan, it's a very good question that you have asked. Again, I will draw from telecommunication regulation in Europe. So here, you know what, the problem with law is that it moves slow and the technology moves very fast. And more often than not, we do make mistakes. So the telecommunication regulation in Europe says that in case of uncertainty, the law needs to move very gingerly, very carefully. At the same time, we have a case law like 102 versus Commission, where the ECJ said that even in the case of economic uncertainty, law does not have to sit idle. It has to take certain steps. So we have a great task ahead, but have faith in the process of market. But wherever the outcome is pretty much clear that non-intervention would lead to consumer harm, we need to move fast. And in digital economy, by now, I think it's very much clear that harm is taking place. Killer acquisition, we do not have any answer for that. There were certain abuses which could not understand at the time when these cases came to the antitrust watchdogs. And picking up from one point from Shilpi's presentation, like why is CCI acting so proactively, whether in the WhatsApp case or in the Make My Trip case? It is acting so proactively because perhaps it is trying to make up for the deficiency or absence in other regulations. Had we come up with a personal data protection bill, perhaps the WhatsApp case that the competition and privacy paradox that we are discussing, or we would not have been discussing, the consumer welfare would have been taken care of through the PDP bill. And MMT case, when some one particular party was deplatformed, maybe platform to business regulation would have taken care of it. So going back to what I have to tell you, that it is pretty much clear that we have to move. However, we have to first respect the market. If the market can correct themselves, do not touch them. Here, I have to give it to John, that John, you have pointed out a very good thing, that over-regulation, maybe it would kill the market. But in the case of social media, in the case of online search, there is definitely a need for ex-ante regulation. Thank you, Vivan.
Hemangini, if I can neatly segue from Vikas to you, on this question of if there were more regulators, more laws, maybe the CCI would not need to jump into digital markets so proactively. Do you share that view? And if you do, then what are in your hierarchy of priorities, what are some of the areas where we do need regulation or lawmaking?
So I think I can offer a different perspective here. I don't think there's any right or wrong answer, honestly, but I think every legislative mandate has a specific objective. And I don't believe that if there were, for example, if there was, we have sectoral regulators, we have the TRAI, we have the electricity regulator, we have the PNGRB, and all of them in some way or form also try and protect competition or have a provision which seeks to enhance competition within that sector. But that is not to say that that would take away from the role that the competition regulator plays. The competition regulator's mandate is to ensure ultimately consumer welfare. It ensures consumer welfare by maintaining a competitive process. It doesn't seek to maintain a particular competitor or the benefit to a particular competitor, but maintains a competitive process. And so just to take, for example, the WhatsApp case, I mean, I think there are so many varying views in terms of, whether the CCI was right in interfering in a data privacy question, really, or when WhatsApp was going to change its policy. It had announced that it was going to change, not that it had, that would share certain information with its group companies. I mean, I think there could have been a little more of a robust analysis that perhaps the CCI could have provided in its initiation order to say why this would be necessarily a competition issue, keeping in mind that the goal of the Competition Act is consumer welfare, and and why data privacy is a factor that is so important for the Commission's analysis as compared to, say, the benefit. For example, it didn't even consider what the benefits of, say, this data sharing could engender. Not to say that there will be certain benefits, but I think there should be certain discussions both on both sides. So I feel like even if there was a data regulator that was looking at this, is it to say that the competition regulator can't look at other aspects of a particular conduct of a company? No, I think the objectives are going to be the defining feature here for when the competition regulator should step in. Even the Act, I think, considers this, where I think there's a provision in the Act which says that when CCI can reach out to other regulators to get an opinion to understand better how that industry works. It's not to take away the jurisdiction of the regulator, but to work in tandem, because all laws do not, address all issues that different legislations can do. And and especially the Competition Act, because the regulator is looking at all sectors. If each sector was to be governed by their own regulator, then why have a generalist, not generalist, but a competition regulator that's supposed to examine this? So I don't. I think there are various ways of looking at this one thing.
John, you had a point to make. If you still have that, please do. But I also just received a question from the audience, which I think is worth grappling with, which is that can you today even think of creating a platform like YouTube to stream like this? This can still be possible, but will you be able to scale it up without using Google? And I think with respect to what you had earlier said around the case for VOD and disintermediation, in the case of OTT and TSPs, in the telecom study, CCI has actually observed that in general, across the digital economy, and I'm quoting from them, and arguably elsewhere, the relationship between size and antitrust has become more subtle. So John, maybe you can leave us with a few nuggets on size, scale, and digital markets. Can we overcome some of these traditional market challenges just because of this disintermediation?
I just wanted to comment on one thing, Vivan. I think we often forget what digitalization has done for us, right? You would remember, all of us remember back, maybe 10, 15 years ago, it would take about, let's say, a manufacturing Indian company to be global, 10, 15 years to be global? The wonderful thing about digital platform is the moment you start, you are global. Now, the moment you start and you start competing with the likes of, let's say, the Facebook and Amazon of the world, are you saying that that they are creating a barrier for you? So I think there's a lot of questions to ask. We need to ask ourselves, because we also need to understand that the moment you start your business, you've just become global, right? So I think, so in terms of the VOD market, especially, I feel that there's a plethora of opportunity. And I think when you look at, let's say, and I think it's possible to exist, create that niche for yourself without, the Googles of the world. And I think there are examples of like this. You have Twitch that is becoming very popular in the US, right? And who knew that market existed for it? So I think the market, rewards somebody who is creative. And if you're creative enough to find that, let's say, innovation, and find that innovate and find a market for yourself, I think there's in the VOD space as well, I think there's enough room for everybody to grow.
If I can quickly, we're very close to the finish line and don't want to keep anyone away from their dinners. But Meghna, you've heard everyone. You started this discussion with your expert comments, and I just want you to leave us with a few, if you feel there are a few principles or best practices that perhaps address some of these challenges we've discussed today, and what would those be? A quick sort of rapid fire response from you, and I'll hand it over then to Richard to close the session.
Right. Thank you, Vivan. So basically, when we look at the regulatory experience of India and what has happened so far, we see that there's no standardization across processes and there's a lot of ad hocness across different sectors. So things like a consultation policy, how long a consultation should be alive for. For instance, in the US, is generally about 1 year, unless it's a really, really small issue. Then the imperative for the regulator to carry out an impact analysis on regulation before coming out with new regulation, that is something that is missing as well. And finally, all these things should be standardized before we bring in a digital regulator and start calling for ex-ante regulation in digital markets that are a lot more vulnerable to adverse determinations and a lot more prone to shutting down.
Thank you, Meghna. Let's just end on an optimistic note. I think everyone has agreed that the CCI, like other best-in-class competition regulators, does rely on a lot of academic literature and reports to make its determinations. I think there can be no quibble, no quarrels around that. But what one can quarrel with is the amount of qualitative literature that is put out, qualitatively good literature that is put out by the Indian academic community and civil society on some of these most pressing questions. I think we have to endeavor to go beyond the first level of understanding that we infer from the debates in Europe and US, and start to position some of these debates through an Indian lens for the public interest in India. And this is what we are endeavoring to do here by bringing together academia and practitioners and policymakers. We hope to continue this effort and hope to convert this into a series, invite other academic institutions to join in. We invite industry to join in. I'm told that, for instance, you talk so much about Facebook. Facebook is also, investing in research around these questions. I think we should debate the ideas that come out of this research that hopefully these kind of processes foster. And hopefully we can make this a series and not a, just a discrete interval in time and space where we paid attention to these very important questions. And thank you very much, Jindal Global University, for enabling this, and hopefully we can continue these interactions in the future. Thank you, Richard.
Thank you, Vivan. And on behalf of OP Jindal Global University and the Jindal Digest for Competition and Innovation Laws, I thank everyone, the speakers and the attendees, for joining us in what has been an extremely interesting and engaging conversation. We, along with SCR, like Vivan said, hope to continue such conversations and hope to bring academicians, lawyers, and students to a similar platform so we can all share our views. So until next time, thank you, good night, and I hope you have a wonderful weekend.
Thank you. Thank you. Thank you.
Thank you very much.
Thank you.
Thank you very much. Bye-bye.
Thank you.
Thank you.